Hi, students. I hope you're doing well. This lecture is the beginning of Unit 9. Unit 9 is Trial and Punishment. This unit's covered over week 15 and week 16 of this course. Week 15 will be on criminal trials, and then week 16 will be on punishment. When we talk about trials, when we talk about a criminal case in particular, guilt of a person is established either by a plea, so the person will plead guilty or no contest, typically, or the other way guilt is established is through a trial. A person has a right to a jury trial, but a person can waive that right and have a court trial. But that is how guilt is established. Remember, in a criminal trial, the burden is on the people. It's always on the people, on the government, to prove their case by the highest standard of due process. That's beyond a reasonable doubt. So the government has to prove a person is guilty beyond a reasonable doubt. The defendant in a criminal case does not have to do anything to establish their innocence at all. So these safeguards that are in play here are from the Due Process Clause. Remember, the Fifth and 14th Amendments provide that a person cannot have their life, liberty, or property taken away without due process of law. So it's the Due Process Clause that comes into play here. So what are the safeguards that are in effect during the trial and actually punishment phases? But we'll talk about punishment, as I said, in the next class. But these protections include the protection against double jeopardy, the right to a speedy trial, the right to a public trial, the right to confront adverse witnesses, the right to an impartial jury or an impartial judge, the right to a jury trial, and also protection against cruel and unusual punishment. So these are the types of protections that are provided under the Constitution. I want to talk first about the Fifth Amendment double jeopardy prohibition. The double jeopardy clause of the Fifth Amendment provides that a person shall not be subject for the same offense to be twice placed in jeopardy of life or limb. So this, what we've referred to as the double jeopardy clause, includes preventing the government from trying and accuse more than once for the same crime. And secondly, prevents the government from imposing more than one punishment for the same crime. The purpose of this clause is to prevent the government from using its resources over and over to retry a person until that person is too worn out to continue with a defense. So in other words, if the double jeopardy clause was not there to protect you, the government could just continue to try you over and over until they get the result they want. Now this would have a big impact on a person emotionally, financially, would have a huge impact on a person. And so the government cannot do that because of the double jeopardy clause. And the colonials were well aware of the abuse by the king and Parliament, and they wanted to include protection from that abuse in the Constitution. So when you talk about the double jeopardy clause, it means that there's going to have to be multiple prosecutions. So there will be multiple prosecutions. So the three conditions must be met in order to have protection from a second prosecution under the double jeopardy clause. First, the earlier or the first prosecution must progress to the point of jeopardy attachment, and that first prosecution must end in acquittal, mistrial. It must end. The second prosecution must involve the same offense, and both prosecutions must be brought by the same government entity. So when does double jeopardy attach? In a jury trial, double jeopardy attaches when a jury is sworn in to hear the case. And in a court trial, which is a trial before a judge, jeopardy attaches when the first witness is sworn and begins to testify. So once a person is past the point of jeopardy attachment, it cannot be retried for the same crime by the same sovereignty. Now, when does jeopardy attach? I mentioned that in a jury trial, it's when the jury's sworn, and in a court trial, when the first witness is sworn and testifies. Now, there's exceptions to this. One is where the defendant actually requests a dismissal, or there's been a mistrial in the first case before the verdict. So before a verdict, the defendant requests a dismissal and it's granted and the case is dismissed, or there's a mistrial granted before verdict, then of course the person can be retried. Also, another exception is the judge will grant a mistrial for manifest necessity, which typically is a hung jury. So if there's a hung jury, then and the case is dismissed, then the person can be retried. And then also a third exception would be if the person's convicted, the person appeals, it's reversed on appeal, then the person can be retried. So when we talk about the same crime, you can't be tried twice for the same crime. Same crime, there are two tests, the same elements test, and the second is the same transaction. The same elements just means you look at the elements of the crime. If they're the same, it's the same crime. Transaction is a little bit different. You look at the transaction, the criminal transaction the person was involved in, and did that crime come from that transaction? Even though it's a different crime, if it came from that transaction, it's considered to be the same offense for the purpose of the double jeopardy clause. And then same sovereignty means state or federal. We have a dual system. We have the state system and we have a federal system. And the reason for that is because of in the beginning, when the states gave some of their power to the federal government, they created a dual system, a federal system and a state system, and those two systems are considered to be separate sovereignties. So that's the double jeopardy clause. It can be somewhat confusing, but make sure you just listen to this again if you need to, read it through your book, and I think it'll become clearer to you. The double jeopardy clause also prohibits more than one punishment for the same crime. This punishment, though, does not include any civil penalties, because a civil penalty is not a punishment, a criminal punishment. So civil commitments are not included. For example, if a person is convicted as a sexually violent predator and they are sentenced to prison, before they're released, they can actually receive a civil commitment as a sexually violent predator and stay in a civil commitment potentially for the rest of their lives if they are still a danger to the community. That civil commitment is not prohibited by the double jeopardy clause. It's not considered to be punishment. Asset forfeiture is another example. So if a drug dealer is stripped of his assets and they're forfeited by the government, that's not considered to be a punishment. It's considered to be a civil penalty for what he did. Also, if you're licensed, for example, your driver's license is suspended for driving under the influence of alcohol, that's not a punishment. That's done by DMV. That is an administrative suspension, and it is not considered to be punishment. So those types of civil penalties are not punishment under the double jeopardy clause. So what about a fair trial now? The Fifth and Sixth Amendments require a fair trial. The requirements for a fair trial include a speedy and public trial, an impartial tribunal, either jury or judge, trial by jury, and also right to confront adverse witnesses. So let's talk about speedy trial here. The right to a speedy trial is guaranteed by the Sixth Amendment, and it attaches once the person has been charged by the government. Delays that occur before charging are examined under the Due Process Clause or statute of limitations, but not the Sixth Amendment right to a speedy trial. The right to a speedy trial under the Sixth Amendment is after the person has been charged. In assessing whether a federal right to a speedy trial has been denied by the court has to consider four different factors, and this is under a case called Barker versus Wingo. First of all, the court will consider the length of the delay, how long, in other words, the reasons for the delay, whether the defendant asserted his right to a speedy trial or agreed to the delay, and any prejudice to the defendant from the delay. So, for example, in Barker versus Wingo, if you read that case, it was two defendants. They separated their case, so one defendant went first, and the other defendant, the second defendant, just agreed to basically follow behind the first defendant. So once the first defendant's case was done, the second defendant case was started. The trial was started for the second defendant. Well, the second defendant made a motion to dismiss for violation of his right to a speedy trial, but the court said no, because you agreed to the delay by agreeing to follow behind the first defendant. And not only that, there was no prejudice to you by this delay. You didn't lose any witnesses or anything like that. So you weren't prejudiced by this delay. So therefore, you were not denied your right to have a speedy trial. There are also speedy trial provisions in the state, in the states, including California. So, for example, by statute in California, on a misdemeanor, you have a right to a speedy trial within 30 days of your arraignment if you were in custody at your arraignment, or 45 days from your arraignment if you were out of custody at the time of your arraignment. And then on a felony, you have a right to a preliminary hearing, and if you're held to answer for trial, you have a right to a speedy trial within 60 days of your arraignment on the information. So you have those statutory speedy trial provisions in California. Now, of course, you have a right to a speedy trial under our federal constitution. You have a right to a speedy trial under state law. But remember, although you have those rights, a person can waive those rights and agree to delay their trial. And there's different strategies involved there. For example, a defendant might waive his right to have a speedy trial in a domestic violence case, hoping that he can make up with the victim or the victim will lose interest. On the other hand, a person that is charged with a serious crime may want to have a speedy trial because a lot of the evidence has to be tested, and he feels that they cannot be ready, to present that evidence if he gets to trial sooner rather than later. So that's a right to a speedy trial. Remember, another right is a right to a public trial. The right to a public trial is also guaranteed by the Sixth Amendment. The right to a public trial and public trial is very important. It ensures that truth is told by the witnesses, induces witnesses that have information to come forward. And also, I think the last reason is the most important, is to make sure that justice is done. Because if you have a public trial, that means the public can come in, watch, and hold everybody accountable. It's not a trial that's done in secret or hidden from the public. The public can come in, the public can watch, and the public can make sure that justice is being done. The right to a public trial not only includes the trial, but it includes all the preliminary pretrial proceedings. It includes jury selections, motion to suppress, the arraignment, preliminary hearing, bail reviews. There's a lot of pretrial proceedings in court that are also open to the public. To close a criminal case, it requires urgent circumstances where exclusion of the public is necessary to serve higher values. So the court, when there's a request to close, has to consider other alternatives before closing the proceedings and make findings to support it. Also, if there is going to be a closure, if possible, that closure should be very limited. Maybe you close only for the testimony of one witness, but otherwise the trial's open to the public. So, for example, in a case involving a crime against a minor, there might be a motion by the minor to close part of the trial to allow the child to testify because the child has been, you know, under psychological trauma from the crime and having to testify, and having that person or child testify in public would cause additional trauma to that child. So they would make a motion to close. And the court would, of course, just can't automatically close. The court would have a hearing, hear the evidence, make a decision, make findings, and then make the appropriate orders. But remember, it's not only the public that has a right to be in a trial. Also, the media has a First Amendment right to attend criminal trials, criminal cases. So when you close, you're not only excluding the public. If you exclude the media, you could be potentially violating their First Amendment. So the court has to be very careful in making a closure, because if the judge closes and it's wrong, and there's an appeal, it could result on a reversal of the conviction and a remand for a new trial. So it's very important that the judge handles that correctly. Also, another important right is a confrontation of witnesses. The Sixth Amendment guarantees the accused the right to be present during trial, to face the witnesses against him, and to cross-examine them in court, in open court. It's that creates an adversarial process. The government on one side, the defendant on the other side, and it's through this adversarial process they say that the truth will emerge. The truth will come out, and the jury will determine that truth through this process and then come to the right conclusion in the particular case. Also, remember, everyone has the right to have a fair and impartial trial. That's under the Sixth Amendment. And when I say impartial tribunal, I mean either an impartial jury or impartial judge. So if a person has a right to a jury trial, remember they can waive that right. They can have a court trial or trial by judge. The judge, first of all, has to look at him or herself and decide, am I biased or prejudiced against this defendant? If that's so, the judge should recuse themselves from hearing the case. Also, the defendant, or actually either party, has a right to challenge the judge. Each side has one peremptory challenge against the judge. They don't have to give a reason. And if it's filed timely, the judge has to recuse himself or herself. And then also either side can challenge a judge by, if they believe the judge is biased or prejudiced, they can file a challenge based on that. And there's a procedure that has to be followed to determine if that judge is truly biased or not. But also this right to a fair and impartial tribunal applies to a trial by jury. So there's a process that is in place to pick a jury that is fair and impartial. It doesn't mean that these folks have not heard about the case. It means that even if they have heard about the case, they can set it aside, be fair and impartial, try the case based on the facts in the courtroom, determined in the courtroom, and the law that is given to them by the judge. So obtaining a fair jury is a process, and it starts by the jury commissioner, and every court has a jury commissioner. They send out a summons to people in the community to appear for jury service. And once they appear and check in, um, they have to be qualified. So that's one of the first step is they have to be qualified. So you have to be over 18. You have to speak English or understand the English language. You have to live in the county where the crime committed, no felony convictions. And those are pretty much the qualifications. Um, so if a person is not qualified, they should be excused. The other issue is the issue of hardship. So I know serving on a jury is inconvenient for a lot of people, but for some people can actually be a hardship. But it has to be a personal hardship. It can't be a hardship on your employer or somebody else. It has to be a hardship on the individual. And the law recognizes certain uh, categories that are hardship, and the judge will hear all the excuses for hardship, and then the judge will decide whether or not to grant a hardship. So you can see from the summons issued by the commissioner, you are reducing the number of people that are available now for this trial. You've reduced them because some are not qualified. You've reduced some because they have a hardship. So the next thing will be a period of questioning. The judge will question first, then each attorney will. And they'll question and ask questions like, well, do you know the attorney for the defense? Do you know the prosecutor? Do you know the defendant? Do you know any of the witnesses? Have you heard about the case? So they'll ask all those different types of question. And then when they're all done, there can be a challenge, what they call a peremptory challenge. Um, Actually, before a peremptory challenge, there's actually a challenge for cause. A challenge for cause means a juror's actually has actual bias against one side or the other. Remember, each side is entitled to have a fair jury. So if the person is actually biased against one side or the other, then that person is excused. So each side has an unlimited amount of these challenges for cause. Um, and for example, a person might say, Your Honor, I can't be fair here. I just believe this person's guilty. And the judge might ask him, well, you haven't heard the evidence. You have to hear the evidence. You have to decide the case based on the evidence and the instructions. And if the person is adamant, I just can't be fair, Your Honor. I just believe he's guilty. Then that person should be excused for cause. So after the challenges for cause have been completed, then the court will also um, entertain any challenge, any peremptory challenge. A peremptory challenge is just a challenge. They don't even have to give a reason. But a challenge, peremptory challenge, each side has a specific number of them. Mostly it's 10 on each side, and they just alternate back and forth until they've used them or they're satisfied with the jury. So you can see through this master list, the summons goes out, and then there's qualifications, hardship, challenges for cause, peremptory challenges. And then finally, through that entire process, you end up with 12 people that can be fair and impartial. Those 12 people are sworn to hear the case. And then the court will pick alternates the same way, same process. Usually they'll pick a minimum of 2, sometimes as many as 6. It just depends on the complexity of the case and how long that case will go. Sometimes there's a pretrial publicity that can pose problems for a fair and impartial trial if people are listening to this pretrial publicity. So there's different ways to remedy that situation. In a criminal case, the judge can issue a gag order. The judge cannot gag the press because they have a First Amendment right to freedom of speech and freedom of the press. But the court can gag the participants and witnesses from discussing the case with the media. That's one. The judge could continue the case because of pretrial publicity. The problem with that is there's a delay, and sometimes when the case starts back up again, there's a pretrial publicity again, so it doesn't really accomplish what the judge wanted to do. You can sequester, but that doesn't That's very expensive. That means you're locking them up every day until the case is done. They did that in the O.J. Simpson case, but it was very costly, very difficult. Frankly, just not done so much anymore. Another way would be to change venue. If it's so bad, then there can be a motion to change the venue. In other words, move the trial from Madera County, say, to Stanislaus County. We had a murder case years back, and that's exactly what happened. There was a motion by the defense, granted by the judge, to change the venue, and eventually it was changed to Stanislaus County. So the judge was from Stanislaus, the jurors from Stanislaus, but the witnesses were the witnesses. The prosecutor and defense attorney were all from down here. They just ended up driving up there to handle the case up there. So I want to talk to you about trial by jury. Trial by jury is guaranteed under the Sixth Amendment. It applies in all criminal cases, except for petty offenses less than 6 months of confinement, criminal contempt with less than 6 months of time, military proceedings, juvenile proceedings. You do not have the right to a jury trial. Sentencing, you do not have the right to a jury trial. That's sentencing is done by the judge. So you have a right to a jury trial. So what about the size of a jury? At common law, trial by jury was 12. It's not clear where the number came from. Some people argue the 12 tribes of Israel, 12 apostles. There's different explanations for it, but it's not clear where that came from. This requirement of 12 is required in federal cases and used by most states, including California. States are free to reduce it, but not below 6 in felony cases. Verdicts are required under the Sixth Amendment, requires a unanimous verdicts in federal criminal cases, but permits less than unanimous in state court cases. California is unanimous. I think there may be only 2 states that allow less than unanimous, but a majority of the states and almost all of them require unanimous verdict. I talked about jury selection. Remember, when the commissioner sends out the summons to appear for jury duty, the summons that goes out has to go out to a fair cross-section of the community. And the way that the commissioner determines that is by collecting names and individuals that are in the community to send a summons to. They collect their names from voter registration, vehicle registration, driver's license, property ownership. There's a number of ways that the commissioner obtains names of folks in the community. They combine that information into their system, and from that they generate a summons. So it has to be a fair cross-section of the community. Lastly, I want to talk about is preservation and disclosure of evidence. The defendant's due process right to a fair trial is violated, entitling the defendant to a new trial when the police either fail to preserve and disclose the evidence according to established law. So if the police fail to preserve it or fail to disclose it, then that would violate the defendant's right to a fair trial and entitle the defendant to a new trial. So disclosure, let's talk about disclosure. Disclosure, say in California, is most of it's discovered are provided for in by statute. So California in the Penal Code, there is what we call a discovery statute. It requires the prosecutor to provide automatically to the defense certain discovery, police reports, lab reports, and so forth. There's also in California a reciprocal discovery that requires the defendant to provide information to the prosecutor. The idea is that when this case goes to trial, both sides have the same information, both sides are ready and prepared to go to trial. There will be no surprises at trial. It'll be fair. It'll be equal. Each side is on equal footing here. So that's the idea behind that. Now, there's also discovery generally by statute in California is very informal. So one side would make an informal request, and then if it's not provided, then either side can make a formal motion in court for discovery. That's done before trial, heard by a judge. The judge hears the request and then makes the appropriate order for discovery. There's also a federal case called Brady versus Maryland. It's a very important case. And this case requires the prosecution. They have an affirmative duty. They don't even have to be asked for this, but they have to look for it and they have to provide it. And it's not only evidence that's in the prosecution's possession, but it's also evidence in the possession of law enforcement. And it's any evidence that tends to show that the person did not commit the crime. It's exculpatory evidence that they didn't commit it, or there's evidence that exists that can help the defendant's case to impeach any witness, any government witness. So this evidence is evidence that is favorable to the defense, and it can negate his guilt or reduce the credibility of a witness. And if the government has it or law enforcement has it, they have to disclose it. And if they have it and they don't disclose it, it'll be automatically reversed on appeal. So that's disclosure. What about preservation? Generally, police are required to preserve the evidence. However, there's a U.S. Supreme Court that said that failure to preserve evidence will only violate due process if it meets three criteria. One is the exculpatory value of the evidence was apparent to the police before it was destroyed, which means that the evidence tended to show that the defendant did not commit the crime. That's what exculpatory evidence is, shows that the defendant did not do it. Then the other element or criteria is the evidence cannot be replaced. And third, that the evidence acted in bad faith when they destroyed the evidence. So it has to meet those three criteria. And if it does, then it would violate due process. So, and then the case that I was referring to was Arizona versus Youngblood. So that is the section Unit 9, which corresponds to Chapter 9 of your book. It's on trial and punishment. This is week 15. This covered trial. Next week, we're going to talk about punishment. And then after you're done with week 16, which you'll be done with Unit 9, Chapter 9, then you go into your very last unit, 2 weeks of your last unit, and then you end up taking your final. So I hope you're doing well. Hope you're hanging in there. Take care of yourself, and I'll look forward to presenting the next lectures. Okay, take care. Bye bye.